Good afternoon. Welcome to our Legislative Changes Affecting Public Works Contracting webinar. This is Judy Isaac, MRSC Public Works Consultant. With me are Oscar Ray, MRSC Legal Consultant, and George Kahn, Executive Director of the Washington Public Utility Districts Association. The scheduled time for the webinar is about 60 minutes. Our panel presentation will be about 40 minutes, followed by questions and answers. So just a few quick technical comments. You should have a toolbar on the right side of your screen with a handout section and a section for questions. If you don't see a toolbar, it might be collapsed. Click on the orange arrow to maximize it. The handouts provided in the available link can be printed out at any time. We will be taking your questions through the questions dialog box. Just type your question where it says type message here and click send. Questions can be submitted at any time throughout the presentation. If you don't see the questions dialog box, clicking the red arrow that allows you to expand the GoToWebinar controls should make that available to you. If we're not able to answer all your questions today, then we'll respond to you after the webinar. And as always, feel free to contact us with questions by telephone or by email using the contact information that you'll see at the end of the presentation. Following the conclusion of the webinar, a survey with 4 questions will pop up on your screen, and we would appreciate your responding so that we can make any needed changes to future webinars. We'll post a recording of this webinar on the MRSC website and send you a link in a follow-up email in case you'd like to listen again. Hi, this is me, Judy Isaac, MRSC Public Works Consultant. Oscar and George, please introduce yourselves.
My name is Oscar Ray, and I'm a legal consultant at MRSC. Prior to that, I was an assistant city attorney at the city of Kirkland. I would also like to acknowledge the contributions of John Carpita to this webinar. As many of you know, John has done this webinar for many years. John retired at the end of June, and he provided a lot of support and advice to us before he left, both in general and on this webinar. We wish him the best in his retirement.
Good afternoon. My name is George Kahn. I'm the Executive Director of the Washington Public Utility Districts Association. We represent 27 public utility districts in the state of Washington at the legislature and at the federal government level.
Our agenda for today has 3 main divisions: legislation affecting all local government agencies, legislation that we wish would affect all local government agencies, legislation affecting only some local government agencies. We will also briefly discuss the recent case of King County versus Vinci Construction, which was decided last week by the Washington Supreme Court. It addresses the ability of government agencies to recover attorney's fees in disputes with sureties over performance bond coverage.
So let's start with legislation affecting all local government agencies. The first legislation we'll discuss is SB 5734. The bill will change requirements for bonding and retainage on small public works. The statute amended is RCW 39.08.010, which is the provision that requires performance and payment bonds and retainage on public works projects. The current version of RCW 39.08.0103 provides that on contracts of $35,000 or less, the public agency may hold 50% of the contract amount for a period of 30 days in lieu of the required bonding. The new legislation changes the requirements of the statute in the following respects. First, it raises the dollar threshold from $35,000 to $150,000. Second, it lowers the retainage percentage from 50% to 10%. Therefore, as of July 23, 2017, this option will be available on public work contracts of $150,000 or less. It is not limited to small works roster contracts. It can be used on any public works contract under that amount if requested by the contractor and agreed to by the public agency. I do want to briefly discuss the significant change in the limits and retainage percentages. It's a lot easier to waive bonding on a $30,000 project when there is 50% retainage. Agencies will want to carefully consider whether to waive bonding on bigger jobs, such as a $145,000 project in which only 10% would be held as retainage. The legislation also provides that claims for prevailing wages have first priority in actions filed against the retainage. This is not really new because it reiterates RCW 60.28.040 subsection 5, which already provides for first priority for prevailing wage claims. Finally, RCW 39.08.010 subsection 4 allows public agencies to accept performance and payment bonds on contracts of up to $150,000. Previously, the limit was $100,000. These changes were adopted in order to make the state's bonding requirements consistent with federal small works bonding requirements. So who decides whether bonding will be waived? The language of the statute indicates that this may be requested by the contractor, but the decision of whether to do so is discretionary with the public agency. This language is the same as the previous version, but it's a bit confusing, so it's worth discussing it in more detail. The first part of the sentence states that the bonding will be waived, quote, at the option of the contractor. This suggests that the process is initiated at the request of the contractor. The sentence then states that the public agency may retain. The use of the word may is significant because it indicates the agency has discretion to decide whether or not to waive bonding. It would be a different story if the word shall was used instead. So if the public agency agrees to waive bonds, then it withholds retainage at the rate of 10%. If it does not agree to waive bonds, then performance and payment bonds are still required. We believe this is the correct interpretation of this language, but this is an area where disagreement may be possible, especially if the agency denies a contractor's request to waive bond. If that happens, you should consult with your legal advisor to determine how best to proceed. One final point is that the legislature missed an opportunity to correct the period during which retainage is held after final acceptance. Although RCW 39.08.0103 says 30 days, retainage should be held for 45 days after final acceptance, since that is the time period called for in RCW 60.28.011 for subcontractor claims. Dispersing retainage prior to the expiration of the 45-day period leaves an agency potentially exposed to subcontractor claims. We remain hopeful that this discrepancy will be addressed and eliminated in future legislation. Turning to the second piece of generally applicable legislation, SSB 5301 adds a new requirement to the mandatory bidder criteria set forth in RCW 39.04.350, which applies to public works, and RCW 39.26.190, which applies to vendors of goods and services. The amending language for both statutes is substantially similar. The purpose of the legislation is to avoid awarding government contracts to entities that intentionally violate state wage laws. The new legislation requires a bidder to certify that it has not willfully violated RCW chapters 49.46, 49.48, and 49.52 in the 3-year period prior to the bid solicitation date. These RCW chapters include the state minimum wage provisions, wage payment requirements, and wage withholding requirements. In order to be a low responsible bidder, a contractor must provide a sworn statement that it has not willfully violated these provisions in the 3-year period prior to bid solicitation. But what constitutes a willful violation? For the definition, we go to RCW 49.48.082, and that's the definition that applies. Who decides if there's a willful violation? The statute applies if there is a final and binding citation and notice of assessment by the Department of Labor and Industries, or if there is a civil judgment entered by a court of general or limited jurisdiction. The contractor statement is required to be made under penalty of perjury. There are several steps agencies should take to implement this legislation. First, agencies should update their mandatory bidder criteria to reflect the new legislation. This means that you should update your bid documents and add this requirement to your codes if you have codified your mandatory bidder criteria. It also means that you should develop a form for bidders to fill out and sign that makes the required certification. Do not rely on bidders to provide their own forms for this. Agencies have an interest in ensuring that the language of the form accurately reflects the statutory requirements. So we recommend that you provide the form to bidders in the bid materials for the project. MRSC has drafted a sample form that agencies can use for this purpose. So the MRSC form tracks the statutory language of SSB 5301 as closely as possible. Note that we have a web address for the Word version of the form on the slide if you want to access the Word version online. One thing to note about the form is the point at which a bidder is required to submit it. RCW 39.04.350 and 39.26.190 provide that mandatory bidder criteria are responsibility criteria. That means that a contractor who fails to submit the form with its bid is not necessarily non-responsive. Rather, it means that the agency should request that the bidder provide the form so the agency can determine if it is a responsible bidder. Failure to submit the certificate with the bid documents does not result in automatic disqualification, but it does mean that the low bidder must provide the required certification in order to be awarded the contract. Also, be sure to have your legal counsel review the MRSC certification form prior to using it. MRSC provides sample forms for your convenience, but it is not a substitute for review by agency legal counsel. We encourage your legal counsel to make any revision he or she deems advisable for your agency's use. Finally, a word about effective date. All of the legislation in this update will take effect on July 23rd, 2017. With respect to this legislation, it would seem to apply to projects with bid openings that occur on or after the effective date of the legislation. Bid openings that happen prior to July 23rd, bid openings that happen subsequent to July 23rd, 2017 should include this new mandatory bidder criteria. The third piece of generally applicable legislation is ESHB 1538, which relates to subcontractors and retainage. This is a technical piece of legislation, and it is intended to give subcontractors the option of having the contractor post a bond for retainage. Under current law, a contractor has the option of submitting a retainage bond to the agency instead of having the agency withhold retainage from contract payments. The contractor, at the request of a subcontractor, must accept a retainage bond from the subcontractor instead of withholding retainage. ESHB 1538 provides that subcontractors have an additional method of obtaining their portion of the retainage from the contractor. Under the new legislation, at any time prior to final formal acceptance of the project, a subcontractor may request the contractor to submit a bond to the public agency for that portion of the contractor's retainage relating to the subcontractor. The bond must be in a form acceptable to the public agency and be from a bonding company that meets the standards established by the public agency. Although the statute provides that an agency may not have a minimum requirement that exceeds an AM Best financial strength rating of A-. Within 30 days of the subcontractor request, the contractor must provide the bond to the agency unless the bond is not commercially available or the subcontractor fails to pay the contractor's portion of the bond premium. The agency must accept a bond that meets its requirements unless it can show good cause for not accepting the bond. At this point, I would like to hand this presentation off to George Kahn, who will talk about the unit price contracting legislation that applies to public utility districts.
Thank you, Oscar. Senate Bill 5036. Public utility districts are located in 28 counties in the state of Washington. They provide electricity, water, wastewater, and wholesale telecommunication services. Each public utility district has a different set of services they provide. In our electric utilities, vegetation management and excavation and other work have been conducted through unit price contracts, which have been referred to as on-call contracts, but we suggest the term unit price contracts is much more easily understood by those who are working to try to have legislation changed. It's a contract to a fixed period of indefinite quantity delivery of work or at a defined unit price for each category of work. Next slide, please. So I'm going to provide you with a bit of background on how we got to the point of introducing and passing a bill. PUDs have used unit price contracts for vegetation management, excavation, and other work for many, many years. In fact, the auditor, in a performance evaluation of PUDs, agreed that they were a cost-effective way for public utility districts to do their work. However, in 2014, a number of our PUDs, approximately half a dozen of our public utility districts, began to receive management letters from the auditor saying that there was no clear authority to actually engage in these types of contracts. So even though that they were saving money for the public utility districts, up to $2 to $3 million a year, they were not authorized. The public utility districts responded to the state auditor with their background and legal opinions on why we had the authority to go ahead and conduct and have these types of contracts. The auditor did not agree with our interpretation, and we spent about 2 years working with the auditor to try to convince them to no avail. We also sat down with other public agencies, many who are on this call today, to talk about this issue. And after discussions with other public agencies, it was decided that we would be better off at public utility districts to focus on our own legislation, our own Title 54, to try to get this authorization in place. We developed legislation over many, many months, working with our own project engineers, project staff, and legal team. And then we spent time with the state auditor over the course of a year reviewing the legislation. Now, the auditor would never agree to support legislation, but we got to the point where the auditor would agree that should the legislation be passed, they would be able to connect our unit price contracting with specific statutory authority. At that point, we felt comfortable introducing the legislation, which we did in the Senate Local Government Committee. The bill was introduced and went through the legislature very quietly and very quickly, through the Senate, through the House, on the floor of both chambers, passed the bill, and the governor signed it into law. We had an agreement from the auditor also during this process that they would hold back on sending management letters to the PUDs while awaiting whether we would be successful or not successful in getting our legislation passed. This is a priority bill for the Public Utility District Association this year, and we were very pleased to have it passed. And Oscar, I'll turn it back to you for the next slide.
Thank you, George. So as George explained, currently only public utility districts have statutory authorization to use unit price contracts. However, I should point out that SB 5036 passed unanimously in the Senate and with only one no vote in the House. And so we therefore hope that unit price contracts will become available to other jurisdictions in the near future. So unit price contracts, as George mentioned, are competitively bid contracts in which public works are anticipated on a recurring basis, but the quantity of work is indeterminate. The contract pricing is based on either an hourly rate or unit pricing for one or more categories of work. Examples of situation where unit price contracting is used can include pavement patching and repair, or emergency sewer construction or repair, and there's many other examples. So for PUDs, a unit price contract can be for 3 years with a possible 1-year extension. Under the statute, the extension is at the option of the PUD. Invitations for unit price bids must include, for purposes of bid evaluation, estimated quantities for anticipated types of work or trades. So while the amount of work is indeterminate, there needs to be some estimate made as to quantities of the work or trades. The invitations to bid must also specify how the PUD will issue work assignments, work orders, or task authorizations, as well as specify how payments will be made on the hourly, based on the hourly rates or unit prices provided by the contractor. If electrical facility construction or improvement work is involved, then the contractor must comply with RCW 54.04.085, which relates to the qualifications, experience, and ability to perform the electrical work. Unit price contracts must also be awarded to the lowest responsible bidder. RCW 39.04.010 subsection 5 is the definition of that term, and RCW 39.04.350 is the statute that authorizes the use of supplemental bidder criteria. One issue to consider is how to figure out who the low bidder is in a unit price contract, especially if the bids are close. Some agencies will use a sample project to decide which bid is the lowest if the unit price bids are close together. Finally, there are a few issues to consider regarding unit price contract. The legislation does not address how to handle bonding and retainage in the unit price context. How should the amount of performance and payment bonds be determined when the contract price is indeterminate? Is a PUD required to withhold retainage from each work order payment? And at what point does retainage get released? Would it happen at the end of the contract, or should it happen more often than that? These are questions that are not addressed in the legislation and that PUDs will be required to figure out moving forward. The best approach may depend on the type of contract and the amount of work contemplated. Perhaps these issues can be addressed if unit price contracting is extended to other types of government agencies in Washington. At this point, it is unclear how best to meet these requirements. So the next thing that we will talk about is legislation that affects only certain types of agencies, and we have two pieces of legislation for that. The first is HB 1395, and it provides that every public transportation benefit area authority, also known as transit agencies, may now use job order contracting. Job order contracting is an alternative public works procedure, the requirements for which are set forth in RCW 39.10.420 through RCW 39.10.470. It's available to many other types of municipal entities that meet certain population or revenue requirements, which are set forth in 39.10.420. The second piece of legislation affecting some entities is HB 2052, which provides that the Capital Projects Advisory Review Board, also known as CPARB, may accept late applications for recertification to use the alternative contracting procedures of RCW Chapter 39.10. This legislation gives CPARB the option of accepting an untimely application to renew in order to avoid the alternative of putting an agency through the full certification process again. Of course, agencies won't need to use this process if they track their certification and get their applications for recertification in on time. But it's good to know that it's there in cases where a deadline gets missed. Next, I want to talk about a case that was decided recently, and I thought I would add this since it came in last week, and I thought it might be of interest to our listeners. Last week, the Washington Supreme Court issued a noteworthy case involving performance bonds on public works projects, and it's a case that's helpful to public agencies. So it's a fairly long decision. I'm not suggesting that everybody needs to go out and read it now, but I just wanted to describe it briefly so that you're aware of it. And there's a web address on this slide for the decision if you are interested in reviewing a copy of the decision. The case is called King County versus Vinci Construction, and it involved a major and comprehensive update to the King County's regional wastewater system, what's known as the Brightwater project. The project was very expensive and complicated, and the contractor on that job quickly ran into technical difficulties and fell significantly behind schedule. King County notified the sureties, and the sureties took the position that the contractor was not in breach of the contract, and so the sureties claimed they had no duty to perform under the bond. The delays continued, and eventually King County litigated their claims against the contractor and the sureties. And at trial, the court awarded King County nearly $130 million in damages and nearly $15 million in attorney's fees against both the contractor and the sureties. And the Supreme Court case was just about whether the award of the attorney's fees against the sureties was justified. The sureties argued that the only basis for awarding attorney's fees in a public works dispute is RCW 39.04.240. That statute requires a plaintiff, which in the case of performance bond claims will usually be the agency, to deliver an offer of settlement to adverse parties between 30 and 120 days after the complaint is served and filed. If a plaintiff recovers more than the offer of settlement, it may claim its attorney's fees against the adverse parties. If a plaintiff recovers less than the amount in the offer of settlement, then the defendant may claim its attorney's fees. Interestingly, this process in RCW 39.04.240 refers to and is based on another statute, RCW 4.84.250 through 280. Those statutes apply to civil cases in which the amount sought is less than $7,500. So this is the type of process that may work fine for small and uncomplicated public works projects, but it seems ill-suited to complex litigation. It was likely not feasible for King County to have an accurate sense of the amount of its damages 120 days after it filed its complaint against the sureties and the contractor in a complex case like this. At any rate, King County did not file the RCW 39.04.240 offer of settlement with the sureties, but sought attorney's fees on the grounds that the sureties had wrongfully denied coverage under the performance bond. The court, in a 6-3 decision, agreed that public agencies are not limited to RCW 39.04.240 when seeking attorney's fees against a surety. The basis for this ruling is relatively straightforward. If an agency has to sue a surety in order to receive coverage on the bond, it is only fair for the surety to have to pay attorney's fees incurred by the agency in that litigation. The upshot of all this is there's now more risk to a surety that denies coverage on a performance bond. Hopefully that will help resolve bond disputes more promptly. Of course, if you find yourself in a situation where a bond claim may be warranted, you should consult with and work closely with agency legal counsel.
Okay, thank you, Oscar, and thank you, George. Now we'll be taking your questions. And just a reminder that questions would be submitted through the dialog box at the bottom of the GoToWebinar menu. If you aren't seeing that menu, then click on the orange arrow and that should expand the screen for you. Enter your questions where it says type message here and then click send. So we're going to freeform this a little bit. We've got some questions that have come in. I'll start with the first question here. Could you address, if you weren't already planning to, whether the agency has the discretion not to allow retainage in lieu of a bond or to raise the amount of retainage? What do you think, Oscar?
Well, I think we talked about, we do think that the agency has the discretion to not waive the bonding. It's a more interesting question of whether the agency could seek retainage of an amount greater than 10%. I'm going to have to give that some thought. You know, part of me thinks that if the agency has discretion to say no, that an agency should also have the ability to say, well, we'd feel more comfortable with 20% retainage instead of 10% retainage. So I think based on that, an agency could consider making that case. However, the statute is pretty clear and talks about it being an either-or decision, and so I think I'm going to have to give some thought to whether an agency could really sort of change the terms of the statute and say, yeah, we want to retain 25% of the retainage as opposed to 10% because we're not comfortable with retainage being that low without the protection of performance and payment bonds. So we'll give that some thought here and probably push out or put some information on the website about where we come out on that.
Super, thank you. Okay, next question. Is the bid solicitation date the bid advertisement date or the bid due date?
Yeah, I understand, and I'm going to probably pull up a copy of the bill here. I understand the bid solicitation date as being the date on which the bids were advertised. If I think about the word solicitation, you know, the date you solicit bids is the date that you place them for advertisement according to the procedures that you have for your agency. So I interpret bid solicitation date to mean the date on which you've advertised as opposed to the date on which bids are due. Because there can be cases in which a jurisdiction might agree to extend the date on which bids are due, but the bid advertisement date is always going to be a date that's readily ascertainable.
Okay. So the next question has to do with retainage. What if L&I does not respond within the 45 days after the notice of completion, which is typically the case? Should we still release retainage on projects? And this was asked during the SSB 5301 presentation. Doesn't seem like it's specific to this screen, but I know it's a situation most agencies run into.
Yeah. Well, that's a good question. I think you also, we focused more on the 45-day subcontractor claim period. I think that's actually a good point, which we didn't make in the presentation, that in addition to the discrepancy between the 30-day period set forth in the legislation and the 45-day period that we know applies to contractor claims, you may also want to, and it's probably a good practice to wait until you have heard from, gotten a response from L&I before actually releasing the retainage.
Okay, next question. Does the certification of compliance have to be a separate form, or can it be part of the bid form?
We have it as a separate form. One reason to make it a separate form is that distinction that we made earlier based on responsiveness versus responsibility. And, you know, we talked about the possibility that if the contractor didn't submit the form with its bid submittal, it would have a chance to submit it afterwards. But I think if you incorporate it into the bid documents, I don't see a reason why you couldn't do that. However, you would want to be very clear that there are parts of the bid submittals that do not have to be made under penalty of perjury. And since it's a sworn statement, and I'm kind of going back and forth on this one now, I think the better practice is to make it a separate form because you have aspects of the form that require the declaration to be made under penalty of perjury that don't necessarily apply to the remainder of it. But if you were able to be clear enough that only the portion of the certification, that's the only portion that it was separate and distinct enough from the other parts of the bid packet, then I think you could do that. You would just want to work closely with your legal counsel and make sure that you're drafting it in a way that sort of separates the different certifications that are required.
All right, next question. Can you explain the relevance of subpart 4 of RCW 39.08.010? I see the change from $100,000 to $150,000. I'm just not sure what this section addresses.
And I believe that that section addresses the limit at which an individual surety can be used. It's hard to tell from the context of the statute, but and I'm turning to the section right now. The section itself reads, for contracts of $150,000 or less, that's the amended part, the public entity may accept full payment and performance bond from an individual surety or sureties. And so I think that language simply refers to an increase in the threshold or the limit at which you can use an individual surety. I don't know if it's ever a great idea to use an individual surety, but if a jurisdiction wanted to, it can now do that for contracts of up to $150,000, whereas previously it was up to $100,000. So I think it's the individual surety language that is the significance of that change.
All right, next question. If obtaining quotes on the small works roster for up to $300,000, can the sworn statement be submitted with roster application and be used for any project over that year, or do contractors need to sign for each bid?
That's a good question, and I may want to think about that one a little bit more. My belief is, actually I don't. My belief is that you would need to get a separate certification for each job because the legislation talks about a 3-year window extending back from the date of the bid solicitation. And if the bid is solicited, if you need to have the certification cover that 3-year window, then at the start of the year, if you get the statement and then there's a violation on the part of that contractor in the course of that year, your certification submitted at the beginning of the year won't necessarily cover any violations that happen subsequently. So I think the better practice is going to be to have this certified statement or the sworn statement be provided for each job as opposed to on an annual basis.
Okay, our last question here is regarding SSB 5301 for goods. If a bidder is not located within Washington state, do they still have to certify to minimum wage? Example, they ship items under contract from their location in California to Washington.
Yeah, that's an interesting question, and I'm not sure that the legislation really contemplated that scenario as it relates to goods and services. There is nothing in the legislation that says anything about exempting out-of-state suppliers, and even though it probably doesn't make a lot of sense, I would say that the statute requires those suppliers to make the required certification. The certification is very specific and it refers to state law and it doesn't refer to the other state's law. But I think in terms of just technical compliance with the statute, those out-of-state suppliers, even if they don't have a workforce in the state of Washington, should make the required certification just so you can document that you went through that process. It won't always be easy to tell whether an out-of-state supplier has or doesn't have employees working in the state of Washington or a business presence in the state of Washington that would trigger the certification. So I think the better practice is going to be to require the certification even if you have reason to believe that they may not be doing the type of business in the state of Washington that would result in a violation of those provisions.
Okay, we did have another question pop in, and we have a little time here yet. So here's the next question. Can you explain the relevance? Oh, I'm sorry, we did that one already. This is a repeat. I beg your pardon. Here's the next one. Have the APWA/WashDOT standard specs been amended to reflect SB 5301?
And the answer to that is I don't know, but that is another one that I would be happy to check on to find out. I'd be happy to look in more detail and contact Department of Transportation to find out if those changes have been made to the standard specs or not.
Okay, here's another one. Is the 10% retainage on top of the 5% that is already being held?
My understanding is no. My understanding is that the provision is really covers the situation where you are waiving performance bonds, and instead of you're waiving the bonds instead of taking the 5%, the normal 5%, and also taking bonds. So you would normally take the bonds and retain at the rate of 5%. If you waive the bonds, previously you could do it in the contracts for under $35,000 at a rate of 50%. Now you can do it for contracts up to $150,000 at a retainage rate of 10%, but that 10% is in lieu of and not in addition to the 5% that would normally apply.
Okay, another question. Does wage certification need to be provided by contractor for small works, limited small works, emergency, sole source, or other non-formally bid projects or purchases?
I believe the answer to that is yes. I believe that the statute in its application is not intended to apply simply to formally bid public works projects, but that it's mandatory bidder criteria that applies to all public works projects.
All right, another question. With the new responsibility criteria, when is this expected to be submitted, if not with the bid? Within 24 hours, same as DBE?
Yeah, I think in most cases, from a practical standpoint, bidders are going to submit it with their bid documents. And if you take a technical reading of the statute, though, and think about the difference between the lowest responsible bid versus a responsive bid, if you take a technical reading, one could make the argument that the certification doesn't need to come in with the bid documents. I would imagine that in 99% of the cases, a bidder is going to submit that certification along with all of the other bid documentation that is required. But the distinction we made was to simply leave open the possibility that if somebody didn't submit it, it wouldn't be automatic grounds for disqualification of the bid, and that it could be appropriate to tell the bidder, you didn't submit the certification, we need a copy of it, otherwise we're not going to be able to award you the contract. And you would need to receive it fairly shortly after making that request.
Okay, another question. Would an agency be able to check with another agency, such as Revenue or L&I, regarding a contractor's certification of compliance?
Yeah, I think the statute really contemplates the certification as being the thing that constitutes a satisfactory, investigation. But I don't think that precludes an agency from saying, well, we think we have reason to believe the low bidder may have violated the applicable RCWs. I think you could make an inquiry to another agency in order to be able to confirm, and I don't think that anything in the legislation limits the agency to simply accepting the certification and not looking any further into the issue. I think there's room for the agency to do that in a case where it thought it was necessary or potentially desirable to do so. The other thing I would note is the sworn statement is, the fact that it's under penalty of perjury is designed to be a significant disincentive for a contractor to misrepresent their status in terms of complying with wage laws. So you know, there are penalties or there are potential consequences associated with a contractor falsely certifying that they're in compliance with wage laws.
Okay, next question. On ESHB 1538, if a subcontractor chooses to submit a retainage bond in lieu of retainage held, does the agency then accept the bond for only the portion of the subcontractor's work and then hold additional retainage for the prime contractor's work?
Yeah, I think the agency's decision at that point is really going to be governed by whether the bond that comes in is a bond for the remaining contract amount or whether it's only for a subcontractor's portion of the amount. And if it's the latter, then I think what the agency needs to do at that point is only disperse the portion of the retainage that's covered by the partial bond. So obviously you don't want to disperse any more retainage than what has been bonded for.
Okay, next question. Will the new mandatory responsible bidder criteria be required for all public works, meaning there isn't a dollar threshold?
Yeah, I am not aware of a dollar threshold for the new mandatory bidder criteria regarding certifying compliance with wage laws. I don't think there's any limits on what types of public works contracts it applies to. I think, and if you look at the intent of it, obviously the legislature's intent was to keep contractors who intentionally violate wage laws from being awarded government contracts, and so I'm not aware of any limitations on that.
Okay, for contracts over $35,000 up to $150,000, if the agency accepts the payment and performance bond, do we still withhold 5% retainage?
Yes, yes, you would, because if there's no waiver of the bonds, then the statutory changes we're talking about don't apply, and you default to the normal 5% retainage rate.
Okay, regarding transit agencies that are departments of cities or counties, prior to HB 1395, were such agencies prohibited from using job order contracting?
I view the changes as applying to separate and independent transit agencies, not agencies that are part of a city department. If a transit agency is part of a city, then the applicability of the job order, not the job order, the applicability of the statute depends on whether the city itself is eligible to make use of it. And the RCW sets forth certain population requirements for certain types of agencies and certain types of cities. And so if the city was eligible to use it, then it would be available to the transit department that was seeking to use it.
Does the mandatory responsible bidder criteria apply to bids received through telephone solicitations for projects less than $10,000?
I believe the answer to that is yes. I am going to check, and we're getting a lot of questions on whether the new mandatory bidder criteria applies to certain types of projects, especially small projects. And so at this point I want to double check and make sure that there's not some minimum threshold that applies as an exception to the rule. My belief, based on my review of the legislation, is the answer to that is yes. But I'm going to do a little bit more homework on that one and follow up with additional information.
Okay, next question. Do we have to wait until July 23rd to be able to follow these new guidelines of the 10% retainage versus bonding? Can we start this now?
Yeah, all of these, all this new legislation starts on, takes effect on July 23rd, and so I don't think it's an available option until we reach that date, and unfortunately, I think you would need to wait until July 23rd to be able to do it. Now, the question is whether, you know, if you are in the process of awarding a contract, you know, I think you could probably make an argument that if your low bidder makes the request on or after July 23rd, that it's available even if the contract was bid and awarded prior to July 23rd. So it brings up some interesting issues about the effective date of this legislation, because on a couple of these pieces of legislation we've had to ask, well, what is the triggering event for you know, when the legislation starts? And I would say that after July 23rd, if the agency gets the request, it has the discretion to agree or deny on the question of whether to waive bonding. But if it comes in on the 23rd or after the 23rd, that the agency could then make use of the new contract threshold and retainage percentage amounts.
Okay, this will be our last question then in the webinar. 10% retainage versus 50% seems insufficient, but contractors may request it. Can an agency just say we require bonds for all projects, no retainage permitted, since 10% is insufficient?
Yeah, I think the you know, the important word is may, and so our interpretation of the statute, and this language hasn't really even changed, the thresholds have changed, but the discretionary part of the statute, language of the statute hasn't changed from the agency standpoint. I think the use of the word may means that if a jurisdiction is not comfortable accepting 10% retainage on the contract, that it can say no. And I think the agency always has that discretion, and so if an agency just thought 10% was too low and didn't provide enough protection, it could take the position that it's just not going to agree to agree to requests to waive performance and payment bonds.
Okay, we're just about out of time. If you've got questions and we haven't responded to them, we can address those for you and get those out to you in print in some fashion. We will make sure that you do get a response. But at this time, I would really like to thank everyone for participating. We had a lot of good questions, a lot of good participation. Just a reminder that you will receive a link to the published webinar so that you can revisit the material and share it with your coworkers. Feel free to contact me or any of our presenters if you have further questions or need additional information. Remember, when we all work together to do our best work, our communities thrive. That concludes our webinar. Thank you so much.